So let's move on to the important stuff. What's this webinar session all about? Well, it's about an overview of this decision in Paccar trucks. What does this decision mean? The background of the case, what it means in terms of litigation funding. We're also going to have a delve towards the end of this webinar into what litigation funding is about, and also about DBAs, because obviously this decision is integral in terms of DBAs, the consequences in practice, where we see the landscape of litigation funding going forward, and then some conclusions. So hopefully it will all be interesting during this hour that we've got together. But what does this decision mean going forward in practice? Well, where an LFA does provide for remuneration to the funder based on a percentage of damages awarded, they will now in essence be unenforceable, which may also capture cases where the link with damages is indirect, such as a cap linked to damages obtained. So where it might be multiples of damages, but a cap, it may still be captured on this percentage approach. It is widely considered that this is going to have a huge impact, obviously, on the litigation funding industry. Well, of course, it's bound to. This is earth-shattering, this decision, particularly commercial litigation, and especially claims in the Competition Appeals Tribunal, which I would regard as CAT cases going forward, just to use that acronym at CAT for the Competition Appeals Tribunal, as well as in any other large group actions, of course, which may also be supported by funders in this way, invariably on a percentage basis. Why percentage basis? Because it is more lucrative for the funders. And this is a commercial arrangement, obviously, when we're talking about litigation funding. So I think we've run quite comprehensively through Paccar, and just to give you a good understanding of third-party funding arrangements, litigation funding arrangements, how they work in practice. Now, the key thing now on the back of the Paccar judgment is that if you are going to be sticking with a percentage by terms of reward for a funder, then your LFA has to be DBA compliant. So I thought it would only right and fitting to finish this webinar looking at DBAs for those of you who are not particularly up to speed with what damages-based agreements are. So a damages-based agreement is an agreement for legal services, naturally. It provides for payment on success and a payment linked to damages, inevitably in itself a percentage.